is a wider. It's actually
Yeah, please. Federalism appearing for state of Maharashtra.
has created.
We have to only do it on the basis of understanding.
Practically from
Yeah, please. Well, the common thread in 246, 1, 2, and 3 is the subject matter enumerated in these three list models. If the subject matter is not same so far as the list 1 and list 2 are concerned, then there is no fight between these two entries, and state and union can respectively enact the laws based on the subject matters enumerated therein. If we carefully look at the entries given in both, the matters can be in the nature of activities, places, larger concept like industries. And particularly if we look at the present case, the entry 8 in list 2 is a product specific subject which is there, which is intoxicating liquors. If the intoxicating liquors is a product based subject matter based on which the state is competent to make law, whether the entry given in list 1, 52, which is an entry pertaining to industries, and industries also subject to qualification, union to make law, to take control. So therefore, this being debated in the judgments whether the entry 52 per se is law making enabling entry, or thereafter the until unless law is made, the competence is not driven. But I'll come to that part, Malaz. If I'm able to satisfy that the industry, the subject matter based on which the IRDA was made in 1951, till 1956, the alcohol was not the component or of the schedule which is being given therein. And more interestingly, alcohol is not the declared industry there. Fermentation industry is the declared industry, which has got two products in that. Similarly, if we look at the chemical industry, it has got 15 or 16 products. If you look at the steel industry, it has got the 16 and 17 products. So my first submission is that when we closely read the entry, and that has survived since last 75 years now, this is my respectful submission. A product-based legislation which has been made pre-constitution time also, those are the state excise laws, and then the subsequent rules which are there. All the provisions in these acts pertains to industrial alcohol, or the intoxicating alcohol. There can be different stages. There can be different activities which are pertaining to those products. And in order to regulate and control, a different procedure has been prescribed in states. Nowhere Industrial Development Act has dealt with what is being dealt with the acts which we are talking of, state laws. There can be a difference between the industrial license and there can be a difference between the product license. At the industry level, the governance and regulation can be different, which stems from the provisions of the Industrial Development Act. At a product level, the regulation and governance can be different, which stems from these excise laws. Neither union at any stage made an attempt that we want to govern a product and therefore we'll specify that how alcohol is to be manufactured, stored, moved, removed, and to be denatured, renatured, nothing has been dealt with. Our declaration in section 2 of the Industrial Development Act very clearly says, Union wants to take a control of the industries given in the schedule. Nothing more, nothing less. If we see the index of the entire Industrial Development Act, that talks of the councils to be framed. Councils are going to guide that how the production in the country to be increased. Subsequent chapter says that how the ownership is to be looked into. After a particular date, the industries are existing, industrial licenses to be taken. And 18G is the only one category, and that's also not the category is unconditioned. That says if the union think it is to be determined fair price, it is to be distributed in a particular manner, then under 18G some category is to be, some notification is issued to be certified product ones. Now, to look at this, is there a conflict between entry 52 and entry 8 if we look it from the point of view, and whether in last 75 years at any point, at any stage, the issue has arisen in this context? The answer with great respect is no. Today, there is no law made by union, and that's the reason para 41 of the synthetic, union agreed to this position, saying that both the products are covered in entry 8. That was the basis if we read para 41. So it is not that there is no basis of para 41, and today union says that no, my position is that so far as denatured spirit or industrial alcohol is covered is in the union list. That's not the issue. To make this submission good, I'll rely on I could mail it in the morning, but I'll give a gist of this case. Vijay Kumar Sharma, this is 1992 SCC 562.
Submission?
1990.
I'm sorry, 1990.
Can you just formulate the submission? Because
Yes.
what is exactly
My submission is this, Malas,
Yes.
that entry 8 on a standalone basis, dealing with intoxicating alcohols, give power to the state government to make laws on it, and there is no conflict with the entry 52 in list 1, Malas, because entry 52 list 1 deals with the subject matter pertaining to industries given in schedule 1, which is an industry based legislative competence to be seen. Whereas in the list 8, entry 8, list 2, the product based legislative matter is provided, which is to be seen in 246, 1, 2, and 3. Malas. And this issue came before one of the constitutional benches, and the test prescribed was whether the subject is same in both. And if I'm able to satisfy, and my lords are with
What
me.
is the industry?
Yes.
The product in this respect, the product is a product of an industry.
Yes, Malas.
Which is declared under entry 52. Then what happens?
Malas, if the industry per se, and I'm grateful, Malas, and that's the reason why this debate came, that what is the industry means and why it was in these two judgments specifically restricted, it's to manufacture and not pre-manufacture, not post-manufacture. So the industry per se, Malas, if we look at it, even if the product is given, and if we look at the law which has been framed, a law which has been framed is not at the product level which has been framed, which is framed under the entry 8 in these in the state subjects, or in the state laws. Now the industry to be seen for the purpose, even if the product, one of the product is given.
Industry is fermentation.
Industry is fermentation. And what are the laws which can be made about the industry are, and which are very, very clearly enumerated in the act itself of the Industrial Development Act. And if we'll see the amendment in 2016, precisely give the reason, say that under the 1951 Act, we have to look at the policy to be made in regard to the industries which are enumerated in Schedule 1, not regarding the product. There is not even a single provision in the Act which deals with the a particular product, how the product is to be regulated. That's not the provision which has been there. The judgment which I'm referring to, I'll just quickly give a background. And if we see the entry 52 in list 1, the industry which is to be seen is not an independent entry, a law to be framed by Parliament for a reason, to take control. That's a law which is to be framed in terms of the entry. It's not straight away saying that the law can be made and therefore any industry can be prescribed in this. So there has to be law specifying to take control of that particular industry, which is this particular Act of 1951 is. So it's not an open-ended power or legislative competence which can be driven out of this entry. Whereas if we look at entry 8, it is neither subject to any other entry. It is clear open power which is given to state. State, since pre-independence, there are multiple the excise laws which are prevailing, which has been amended thereafter and has been sustained over a period of time. I'll come to the synthetic part.
And under entry 8, according to you, what stages can the state regulate?
Plus
at what point does it cross entry 8, and what is comprehended in entry 8?
Yes, I'm grateful. Plus, thankfully, like the entry 27 and 28, where gas and gas works is given. Entry 8 has taken care of trade and commerce in that particular product also. If we see
entry 33.
No, for the time being, I'm not coming third. Kindly see entry 8 again with me, Malas, for a minute. Because one of the angle in the industry.
So it says, that is to say.
Yes.
Production, supply, distribution.
Yes. So if I for understanding purposes say, what does a trade commerce means, Malas? Trade commerce potentially can mean the production, manufacture, possession, transport, purchase, and sale. And purchase is an interesting entry in entry 8 itself of list 2, Malas. Kindly see intoxicating liquors. That is to say, production, manufacture, possession, transport, purchase, and sale of intoxicating liquor. Any activity which pertains to this particular product, and there is a reason behind it why this has been prescribed like this. My lords are aware, and it's been debated in last 2 days. Industries are primarily given under entry 24 in list 2. That's the principal entry for industries. There are 2 slices in that. The first slice was the one which I'm talking of, entry 8, on the same day when the constitution was made. Second slice which has been made is out of leftover entry of 24, and the entry 51 was carved out thereafter. And so far as this very product, intoxicating liquor, is concerned, that was sliced out in the beginning itself in the form of entry 8. This was not available in 24 anymore. And therefore, till 1956, till the time the fermentation industry was not the part of the industry declared there, and the alcohol being there, this was not a debate. And that is the reason when we see, I'll show the provision of both the acts, the State Act as well as the Union Act, and the declaration which has been given. That slice which has been carved out in entry 8 is not available in entry 51 is my respectful submission, and that's a discussion. In one of the McDowell judgment, this was precisely the argument Sorabji made before the court, which was accepted by the court. I'll show that argument. Sorry, 52 minutes. 52. So that's once that position is taken, and do we really need to trace the originals? And today we are seeing in the capacity of resolving a dispute. I'll urge and request my lords to see that if it is to be framed today, why
will intoxicating liquor in your submission include denatured alcohol also?
Yes, Malas, I'll give my reasons to that also. First of all, I can straight come to that, Malas. And why do we need to split it? 8 is intoxicating liquors. It is the plural. There was no need to use this. And there is why this is being done is because
then if they wanted to include denatured alcohol, they would have used the expression liquors. Why did they use the word intoxicating?
So it's because the content of alcohol is a measure of a product which is liquor which is to come out. That what is the alcoholic strength of a particular product is going to be determinative factor that whether it is intoxicating or not. Intoxication, a percentage can vary, the composition of a product can vary, and therefore the intoxicating word is used because the liquor primarily, that's what the understanding is in my respectful submission. There is some debate on this. And why this the other product which is denatured is not carved out of this is because all the stages.
What is meant by intoxicating?
Well, the intoxicating certainly means that if it has ability to manipulate the senses of a consumer. Right. So in that case, the And that can be in the, how it is consumed, at what stage consumed can be debatable. But to get into a scientific measure to determine that the intoxication, not in the common understanding to be seen and we need to derive with great respect, may not be the reason. The answer seems to be in the entry itself. Denatured spirit may arise at some stage of all the activities which are given therein. It may be at a production stage, it may be a manufacture stage, it may be a possession stage, a transportation stage. Wherever the makers thought it fit that we have to give a taxing power, it linked with the human consumption. Like in opium, if we see, opium regulation is given in the union list, but taxing entry is given in the state list. So, in a federal structure, the understanding was that these units can operate on their own. The states can operate on their own from the terms of the financial resources, from the law and order situation, and therefore these were carved out. That the regulatory requirements so far as the anything coming out of entry 8, which may have a law and order situation because of alcohol, because we have seen the numerous cases and some coded distillery and all they have raised, that is the social issue and so on and so forth. And there is some requirement of a society order to be maintained. It has been, the governance has been given to the state. And union has been given to power because there's a revenue calculation for whatever may be the reason. For human consumption, excise duty is there. Sales tax, entry tax, GST, today's state can do that. But after 101st Amendment, there is no restraint except the restraint on the excise duty. That part is there. Now to say that we'll read entry 52 and where the law has been framed to take control, it is not an open-ended entry to say that 52 means the union can do anything with a particular industry. It is only with the objective that the control is to be taken. And that's what we see section 11 and 12 of Industrial Development Regulation Act. They say after this, the particular date, the industrial license is to be taken because union wants to, today, how much FDI to come into it. That's the precise reason given in their objective, saying that how much a production of this particular product should be carried out in India, what should be the land size, what should be the capital size, a foreign investment permitted or not, who should be the owner, which industry can be taken control of. That can be very one. As a matter of fact, that has been done by that law. And supposing down. Please, Melissa.
You have referred to 246 to say that these lists operate on various subjects.
Matters, Melissa. Yes. Yes. Kindly see 246(1) for a minute.
Yeah.
Anything, notwithstanding anything contained in clause 2(3), Parliament has exclusive power to make laws with respect to any of the matters enumerated.
So far as entry 8 is concerned,
Yes.
it is a product-based enumeration.
Yes, Melissa.
And the term intoxicating liquor is used twice in entry 8.
Please, Melissa.
So there has to be given some meaning and understanding that it's a product-based entry.
Please, Melissa.
And so far as the industry itself is concerned,
Yes.
you are talking about the IDEA Act,
Yes.
where it talks about that it is expedient in public interest that union should take under its control industry specified in the first schedule.
Absolutely.
So you are trying to make a distinction that when you take over industries,
Yes.
it may have nothing to do with a particular product unless it is said that this particular industry and this particular product. Of
Yes.
course, the schedule to some extent gives a
Yes, it gives a pointer and then 18G, Melissa. 18G specifically says wherever a particular product for some reason is to be regulated, 18G is a power which is being given to the state. It's not that merely because a product related regulation has been given in entry 8, that by virtue of the law frame, by virtue of entry 52, state union is denuded. No, 18G is a power which can be given. And why I'm saying is today we have experience of 75 years. If we see what the law says with the Industrial Development Act says, wherever it has been, and 18G also is not independent. When we read, there is a reason behind 18G. It has survived. Today, well, if we see the referral order, the start point is a paint manufacturer in UP said, I want to buy a denatured spirit. I've been asked to take a form FL41. And he says, I have nothing to do with it. I don't want form for them. Therefore, the law is not applicable to me. That's the start point. Now, all paint manufacturers, all the consumers of denatured spirit are today in one way or the other required to have some kind of a control in possession, use, and therefore need to confirm back that the actual use being there. And the answer is very simple. Excise duty on alcoholic human consumption liquor is 350% in state of Maharashtra. If today denatured spirit for some reason can be renatured, can be converted to consumable, and I'll show that the BIS standards which are there, which can be done, then there is no 350% which is to be paid. So and these are instances after instances which has been taken note of by the state, and the notices have been issued to this, beside the tragedies which are there because there's a methyl alcohol is being used instead of ethyl alcohol in those cases, is being there. So straight away the answer is that if the state is not going to regulate that, and if the alcohol industry, if I say that the particularly treated as industry, the word is alcohol in the fermentation process, a control is given to union with the law we have in place, what happened to those kind of positions which as a matter of fact has been recorded? And that was the very precise basis of aim and object what Mr. Datar read for 2016 amendment. That was the reason. They said we are making this where the human consumption has been taken out of that in spite of whatever the law laid down till 2016. And the reasoning given in the last para is very clear. We want to have a policy control in this, which through the IRDA, which has been done. And never in last 75 years, any attempt has been made to say that the particular industry in a particular state, we want to regulate, control the possession and manufacturing, everything. Not been done. Except these two judgments where say the question came, the industry means what? And there also, it was restricted that because entry 92 talks of control by the union. And the provisions of IRDA give some sense and link with this control by union to the manufacture and production, because Government of India want to have an overall view that a particular commodity, how the steel is manufactured in India, how much steel consumption is available in India, how much import should be permitted in India, how much of foreign investment should be permitted in India. That can be done through IRDA. But somebody say that each steel product specification should be regulated. We have BIS standards, Standard of Weights Measures Act, and the multiple other laws are there. And particularly when we look at the industry which has been given in this schedule, industry has got 17 products. Assuming one product is given herein, and the subject matter based on places, activity are not new. If we look at 5 and 6, ammunition manufacturing, firearm manufacturing, that has been given to the union in list 5 and list 6. This is the way it has been structured. Now to say we will not look at list 8, because it's an industry of alcohol, although it's industry of alcohol is nothing there, it's a fermentation industry which has been declared, which has a component of alcohol or product of alcohol in that. It is not the object. The alcohol word written therein and every species of alcohol get covered, and therefore the state is taken out. With great respect, that's not the purpose. And I'll give a facts of this Vijay Kumar, which I'm saying, Malaj.
In 18G, actually 18G.
Yes, sir.
The IDRA can be partly traceable to entry 52 of list 1.
Please.
Some provisions may be traceable to entry 33 of list 3 also.
Well, yes.
That's perfectly permissible to Parliament.
Well,
so when Parliament says you must have a registration of the establishment, licensing, power to take over management, that is Parliament's power of control, which you find in the first few sections of the Act. If you just look at, if you look at the index to the Act,
yes,
it'll say Chapter 3, regulation of scheduled industries, registration,
Yes, Honours.
revocation of registration, licensing, license of producing,
Yes,
power of central government to specify requirements, revocation and amendment of licenses,
yes,
power to investigate into the affairs of a company in liquidation. Then
Yes.
comes Chapter 3A,
yes, Honours.
direct management or control of industrial undertakings by central government in certain cases. Chapter 3AA, management or control,
Yes,
power to provide relief to certain industrial undertakings.
yes,
3AC, liquidation or reconstruction of companies.
yes, Honours.
Right? Up to there,
Yes,
it may be traceable to entry 52 of list 1.
yes, Honours.
Now, when it comes to Chapter 3B,
Yes,
control of supply, distribution, price, etc. of certain articles, 18G is what we are concerned with.
yes,
That is referable to entry 33 of list 3,
Well-
except that entry 33 also covers production. Entry 33 covers production, supply, distribution. Section 18G doesn't cover production. It only covers trade, commerce, supply, and distribution.
and reason is very obvious, Honours.
Right. Therefore, 18G is Parliament's in exercise of Parliament's power under entry 33 of list 3. Right?
Please, Honours.
Now, therefore, conceivably, Parliament can control trade or commerce in. And though you are saying that the IDRA is industry based and entry 8 is product based, section 18G is product based.
Yes, I'll come to the 18.
Certain articles,
Yes.
which
As
are
on today-
which are referred to in the schedule.
Yes,
So, in relation to 18G, the IDRA also becomes product based. The point which is, however, made by the others, by the lawyers who appeared before you, was of some weight, which is that 18G will come into existence, will apply provided there's a notified order.
please, Honours.
Until date, the union government has never made a
That's
notified order,
Tikaramji, Honours.
right?
Yes,
So, but short of that, for us to say that entry 8 will cover all kinds of alcohol, irrespective of whether it is denatured, otherwise, would be a little extreme. It would be maybe a very extreme view of entry 8. The better view may possibly be, subject to hearing the other side, that entry 8 will not cover
Well, yes, certainly. That's my argument, which I make.
denatured spirit.
Yes, well, I'll come to that part. If we see entry 33 also doesn't deal with the industry, deal with the products.
And theoretically, Parliament, once it notifies an industry as declares an industry to be a controlled industry,
Yes,
it can even deal with the articles of that industry. It has a power then to deal even with the products. Question is whether Parliament delegate, that is, the central government has done so. So long as it doesn't do so, the power is still with the states under entry 33.
kindly see 18G with me for a minute.
Except in relation to denatured spirit. On denatured spirit,
Yes.
the state's power may be restricted.
Well, I'll try and persuade my lords. Kindly see, first of all, my lords are saying by virtue of 18G, product-specific power also come to.
But even on denatured spirit, the state's power may arise under entry 33. That's not a fiscal entry,
Yes, so if.
right? Even in regard to denatured spirit,
Yes,
which goes into entry 52,
yes,
the states still have a regulatory power under entry 33.
yes.
For instance, they can ensure against diversion, they can lay down various regulatory norms. The state is, and for that purpose, it may demand a fee.
Yes, that certainly can be done, Melissa. I have no difficulty on that part, Melissa.
So
So far as,
what is your wider submission?
Well,
Apart from what everybody else has argued, what is it? Because
my wider submission is that that so far as entry 24 is concerned, which pertains to list 2 industry, the industry is in the state list. A carve out is 7 and 52 of list 1.
right.
Whereas if entry 8 is to be seen, which was existing right from the day 1 in the constitution, that as a matter of fact, along with the trade and commerce, what we call it, possession, sale, control, and purchase is only in that entry. Purchase is nowhere else. The reason for that is that if any controlled commodity is to be purchased, like by the paint industry, in that case, the FL 41 can be asked for under the state law. And that's why the word purchase is there. In no other entry, the word purchase is there. It's only in entry 8. But having said that,
There's one thing. I mean, what is Maharashtra's? What's the submission actually?
Well, my submission is one, the state, as a state of Maharashtra, we are competent to make the law which we have made and which we, as on today, are exercising, that the denatured spirit is covered under the entry 8 of list 2. That's my submission once. And the reason for that is twofold. One is a standalone list 8 gives the state power. And IRDA, by virtue of entry 52, is not overstepping that domain. That's my first argument. Second argument is, even if you look,
state can make law on denatured spirits.
yes, Manoj, by virtue of same being part of intoxicating liquors, Manoj. And
that is Mr. Dwivedi's submission also.
yes, Manoj, originally Mr. Dwivedi.
Relying on Balsara.
Yes, Balsara. Second submission is, Manoj, that entry 51, entry 52 of list 1 is not a unblocked entry. It is blocked and a specific purpose controlled by union of an industry. A law is to be made, which is IRDA.
Not what do you?
I'm sorry.
Not an unblocked entry. What do you mean?
Yes, unblocked means it's not an unbridled power that, in regard to any industry, the union can make. That power is in 24. Union need to make a law to take control of that industry, the law pertaining to take control, and that's section 2 declaration of the IRDA. Malaj. If I can read quickly the entry itself, my lords have seen on numerous occasions. Industry, the control of which by union is declared by parliament. It is not simpliciter industry.
Right.
And otherwise the industry is covered under entry 24 of list 2, Malaj.
That is the point. What is the nature of industry under which the center parliament can make?
Yes, Malaj.
You have rightly said fermentation industries.
Yes.
Even if you see this 26 fermentation industry, there is a twofold classification.
Yes, Malaj.
One, it is alcohol. The other is
others.
Other products of fermentation industry. So, under alcohol, they have again made a classification. Alcohol which is potable.
Yes.
Alcohol which is not potable.
Yes, Manoj.
That means it's an indication
Yes.
that alcohol is potable only is under entry 8.
Manoj,
Anything not potable,
yes.
the parliament has the powers in view of entry 52 list 1 and entry 24 of list 2.
My respectful submission, Manoj, even if we look at that indication sum which has been given, if it is an industry specific and a product which has been already given entry 8, will that entry given in that schedule will exclude one of the product out of the product which has been given in entry 8? With great respect, and
it is not the product, it is a classification of a product.
This is the subject matter. The subject matter of framing law.
But then, Mr. Balbir Singh,
Yeah.
your submission is not at variance with what Mr. Datar or Mr. Dwivedi argued. Because their contention also was that denatured spirit also
Yes.
falls in entry 8, step 1.
Yes.
Because it falls in step 8, in entry 8, it can't fall in entry 24.
Yes.
Right?
Yes.
Because following Calcutta gas.
Yes.
If it can't fall in entry 24, there's no question of it being taken out for the purpose of entry 52.
Yes.
Right? That was the line going
What
from
submission
entry
is that?
8 to entry 24 to entry 52. And therefore, according to them, this retains the power of the state under entry 8.
Yes.
So your submission is not different from that.
Effectively not different, but I'm trying to take maybe a step prior to that.
Content of entry 8.
Intoxicatedly.
So I'm only on the subject matter, Malaj. I'll just rely on two judgments.
I think that, while entry 8 is product based, entry 52 is industry based.
Industry based, Malaj. And
There's an answer to it that, entry, IDRA is both product based and industry based. In section 18G, it's product based. There are some parts of it which are industry based, of course.
Today, when we look at the declaration which is given in section 2, the similar declaration, I can quickly tell the facts of this case before in Karnataka, the contract carriage was nationalized. In 1976, law was framed, and all private contract carriage was taken control of by the government by a law. This was in 1976, went to Supreme Court. Supreme Court identified 7 judges before this court, and court said that state is competent, identified the entry with the acquisition and requisition entry in entry 42 in concurrent list. Not tracing to industry, but tracing to saying that the acquisition of property or acquisition of property in 42 is there. 1988 Motor Vehicle Act came in. One of the parties went to the state authority RTO saying that now the 1988 Motor Vehicle Act has come, please give me the registration or license. This issue came to the Honorable Court again. There the issue came that 1988 a Central Act has come in, and therefore these provisions are in conflict. Looking at this provision, and the Motor Vehicle Act was also traced to entry 35 of concurrent list. So both the conflicting entries were in the state list. This Honorable Court said that just to explain, the entry 35 was pertaining to mechanical vehicles. So therefore, 2 conflicting entries were requisition and acquisition of property and mechanical vehicle. These were 2 conflicting entry for Motor Vehicle Act of 1988 and 1970, the acquisition law. This Honorable Court said, if the subject matter is not the same, even if there is an overlap, then they independently they can prevail. Today, to oust the jurisdiction of the state by carving out the denatured alcohol out of entry 8, relying on a schedule, a product given a schedule with respect, this is an independent subject. There the industry has been defined. That's what he argues.
No, I think we'll conclude at this point. We'll take Mr. Faraswat. Yes, Mr. Faraswat. Thank you, Mr. Baldi.
Well, just one part I want to read. From the IS, Mr. Giri argued that so far as the state of Kerala is concerned, that the denatured cannot be converted to renatured. BIS standard, which in para 74, which we looked into in synthetics, simply said anything over 95% is industrial alcohol, although it should be denatured. This was taken note of by BIS standards. I have placed on record, I'll give the page numbers also. They clearly noted that there can be a complete denaturing, there can be a special denaturing. As a matter of fact, where the government has faced a problem is special denaturing, which can be again converted into renaturing, because this was specified for some 25 industries. And there are live experiences that has been converted and sold in the market as a country liquor. Based on that finding, it has been given that the BIS standard which are given is in straight conflict with para 74. That's been a forward which has been by BIS which has been given. So therefore, Mr. Datar pointed out,
in the case of a special denaturing,
yes,
capable of being used again, it's capable of being renatured.
Yes, and it's only boiling point is to be changed. They note that it's a very simple process, and they specify also industry. If my laws permit, I can quickly show that BIS standards which are prescribed this. And as a matter of fact, they said it's been happening, and they specified even what is the boiling point and what the change is going to take place. I just quickly show only one page, and then I'm done with that. I filed my written submission in volume IK, and 1K, sorry. And page 129, which is PDF 129, PDF 130.
BIS standard. What are you referring to?
Well, I'm referring to only the forward of those standards where this problem was specifically noted, and what is the.
Where do we get it? Where do we get it? Volume?
Volume 1K, PDF 130, 130.
Say, now it's not there.
Well, I can quickly read that. There's only 2 paras. I can just quickly read. The third para is completely denatured alcohol, which is CD, and specially denatured alcohol ST formulations are set out in this standard with a specific composition. Both CD and ST formulations are made from the spirit in accordance with the international trade practices. These resulting products are not fit for human consumption. Instead, the products are intended for industrial use. CD, that is completely denatured alcohol, is composed of alcohol and specified denaturants that cannot be easily removed by a simple process and can be used in a number of industrial use. As the denaturants cannot be easily or economically removed, CD is considered to be low risk of, of diversion or abuse. ST, which is the specifically denatured alcohol, is composed of alcohol and specified denaturants that are more readily removed by simple chemical process, while specifically denatured spirit is not fit for human consumption by virtue of denaturants used to denature the product. It can, through certain recovery process, be made potable. As a result, it is its use and control through the registration of users, like the paint industry. Otherwise, everybody user is going to go out. Today, there is no mechanism by virtue of which the user industry, what they do with the denatured spirit which they procure. There is no control except the state laws which are controlling, like through licensing, returns filed by them. There is no law which prevails. And just one more page on this one, how the formula of these two are given, and look at the extent by which these two type of categories of product, PDF 139. A category, the formula for denatured alcohol. A category is completely denatured alcohol, which are safe, are low in risk. Look at B, specifically denatured alcohol. These are the products which are there, and these are regularly being purchased and sold and consumed by the user industry models. And this is under the high risk, as a matter of fact, which has been found to be a problematic area.
Genuinity in making what is non-portable portable.
Yes, but as a straight, I asked this question that why somebody is going to do this. The 350% of the excise duty is saved straight on this one.
Intoxicating.
Even plastic soda.
Medical products like cough syrup.
So you're done now?
That's
Thank you.
great.
So, Mr. Paras, we'll take your submission 15 minutes or so. You can argue to your heart's content, but about 15 minutes. That will then request the other side to start.
5 minutes. 5 minutes.
क्या बहस करेंगे?
हाँ सर.
Yeah.